Thank you. All right. So, Mr. Promise, please can you share with us
Okay,
your reflection about how it's essential for you as a peace ambassador to have to be emotionally intelligent? How important it is for you to
yeah.
not impute your emotion
Okay, so
into resolving disputes, and how you should be able to differentiate, separate, have a clear-cut distance between your emotion and the dispute in question. Please, in 2 minutes, just share with us.
okay, okay. So from what we've learned so far, our role as a mediation specialist is to be able to resolve conflict. So if we bring in emotions into resolving conflicts, there's a probability that we'll take sides. We allow emotion to take over us. We might take side in the case instead of solving the problem. Then we're not putting fire into the process of solving it, but we're already taking side. And also, when we bring in an emotion, it tends to hinder our ability to listen to what each party has to say. Like we won't pay attention to what they are saying, rather we are not paying attention to our emotions and not what each parties are saying. And doing that, definitely there won't be a solution in that case. And also, you as a peace ambassador, the people, the parties you're trying to resolve the issue you're trying to resolve, that's the both parties are trying to resolve their issues. They are looking onto you, the way you act, the way you react to those their cases. Now it will determine the way you react to determine the way they themselves will react to the case. So if you allow your emotion to be triggered, definitely they will see that okay, this person has been compromised by emotion and all that. So it will reduce the trust they have in you. You get. So as a peace ambassador, we shouldn't allow that like our emotions, no matter how the case might seem, we should try as much as we can to take away emotion from it and solve the case that it is. Our aim is to resolve the conflict and not to increase the fire in it. So yeah, so that's it. Yeah, thank you.
Thank you. That's insightful. Thank you so much. All right, Mrs. Adenike, can we hear from you? The importance of separating emotions from the dispute to be much more effective in resolving disputes. Mrs. Adenike, let's hear from you. Mrs. Adenike. All right, that said, seems we can't hear you. Maybe if we have time by the end of the training, you can still share with us. So today we'll be going into the topic communication, dialogue, and active listening for Peace Ambassador. Now, one of the key elements of dispute resolution is dialogue. We said everybody has their story, and everybody is to have the floor when it comes to mediation. Many people just want to be heard. They just want their story to be heard. So, as a peace ambassador, as a mediator, I must ensure that I give each disputant the opportunity to express themselves. I must give them the opportunity to express themselves. I must not cut one person off. And that is where emotional intelligence comes in. If an individual, you're already emotionally corrupted, let me use that word, there is likelihood that you just automatically assume what the other party has not said, and that is what we are going to be seeing in this module. So let's dive in. So what do we expect? We expect that at the end of this module, we would explain the role of communication and dialogue when it comes to peace building. We'll understand the difference between destructive and constructive communication, as well as listening. Now we'll be able to demonstrate active listening and empathic response techniques. So we'll also be able to apply intercultural communication principles to diverse communities. Also, we'll be able to see how to use dialogue to transform conflicts and strengthen relationships. So when we talk about conflicts, initially we said conflicts are not meant to destroy relationship. Rather, they are one another and build a stronger relationship as a reason of the conflict. Because conflict in itself is just a way of a person expressing what they don't want in a relationship. Now, every conflict begins and ends with communication. Every conflict, if a person is willing to fight with you and the person came with fights and you gave a light response, there is likelihood that that dispute would be averted. They used to say that sorry, like in my language, sorry has male and female. You just mean it has different interpretation to the way we hear and receive it. So communication is actually something that can either determine whether there will be a dispute or the dispute will be averted. Now, words can ignite war and ill ones. Now, depending on how the words are used, it can either lead to war or it will what? It lead to peace. Now, for peace ambassadors, communication is more than talking. Communication includes listening, understanding, and bridging gap between opposing sides. So it includes listening, understanding, and bridging the gaps between the opposing sides. Now, for us, we believe that dialogue is the bridge between understanding and peace. There must be a dialogue. Dialogue is the bridge between understanding or misunderstanding and peace. Now, what is the nature of communication? Communication is the process by which people share meaning through verbal and non-verbal messages. Communication is the process by which people share meaning through verbal and non-verbal messages. Now, what does communication entails? It has a sender, it has a message that was sent, there is a channel, and there is a receiver that will now bring about what? A feedback. Now, in that channel, a lot of things can happen that will determine what the receiver received, whether it is the undiluted message or the diluted or corrupted message that was sent from the sender, that will now lead to either a positive or a negative feedback. However, in conflict situation, the process often breaks down because of noise. That's through the channel, emotional tension, bias, cultural differences, or lack of trust. So these are things that can alter the message or through the channel with which it was communicated. Now, when we talk about communication, communication is both verbal and non-verbal. Sometimes just say, I don't like the way the person looked at me. Look, that means there can be a look that would be what? That would be lead to conflict. That is a communication that can lead to conflict. And there can be a look also that can what lead to peace. Now, it is said that the best dress anyone can wear is what? Is a smile. In a room, when you walk into a room and you see someone that having a straight face, or you see someone having a smiling face, who is the person you're likely to go and ask if you need any clarification? It's the person that is smiling, because you believe that this one is welcoming. So I essentially, as a peace ambassador, I must not have a straight frowned face always. Please, I must that is keep a smiling face. Please smile. Smile. Our cameras are off. Wow. As you're listening, just smile. It's something that we must remember our trainers when we did the ICMC. Thank you for the smile. When we did the ICMC course, they're always smiling. I don't want to mention his name. With his cap, he will just smile. Say, says it. After everything, we just say thank you. I appreciate you. Now, by saying that, it looks so personal now. Now, that's a communication, and it actually means that you're actually well appreciated. So, communication is both verbal and non-verbal. Now, verbal has to do with the spoken or written words. Verbal in itself is believed to have clarity when it comes to tone. It's clear you are stupid. If you say something, that's all you are stupid, that means you are clearly abusing the person, or peradventure, when we're younger, that just do the person, your head is mixing. And so those are actually means of communication. Now, in dispute resolution, or we said part of this training is to train us to be peaceful persons, to be able to resolve disputes properly. When disputes arise, it is essential to use the word I, like taking responsibility, than using the word you. Let's look at the example. Said when someone, let's assume that someone hurt you, instead of saying you insulted me and you hurt me, it's essential to just say it like I felt hurt. It is your feeling. It is yours. So why not own up? I felt broken by what, wounded by what happened. Oh, I feel I need healing. Things like that are what would, you are not indicting the other person, because you are taking responsibility for your emotion. Now, in communication, to have communication that will bring about dispute resolution, there is no need to now apportion blames or faults. Now, when we talk about non-verbal communication, we have body language, we have facial expression, we have gesture, we have posture, and we have silence. Many times we take silence as either acceptance or admittal, but many times silence is not acceptance. Of course, we'll see it clearly more in the course of this training. 70% of communication are non-verbal in all human interactions. 70%. People believe what they see than what they hear. So if somebody is smiling to you and the person is doing another thing, you just know that the action, like we say, speak louder than what? Than words, speak louder than voice. Now, in resolving disputes, or when we are also involved in dispute, it is essential that a calm tone, an open posture, a gentle eye contact, it actually conveys respect and safety during the mediation. So it's good to maintain a calm tone. When we looked at the principles of mediating last week, I said that no raising of voice. You are not allowed to raise your voice. You are going to express yourself, but don't raise your voice. There is no need to shout. Now, the power of dialogue. Dialogue is not a debate. Dialogue is not a debate. Having communication to resolve a dispute is not a debate. Now, what is a debate? I believe many of us, we did debates secondary school. Good day, Mr. Chairman, panel of judges, co-debaters, and my fellow students. I was flabbergasted when I heard that they said the man is better than a woman, or farmers are better than teachers. Now, what's the aim of debate? Debate is to what? Is to win. Then you end your debate with, I hope with this few points of mine, I've been able to convince and not confuse you that teachers or lawyers are better than doctors. Sorry, is that illustration is for the purpose of this training. I didn't say that, and you forgive me even if I said that. All right. So debate is for win. Is to win. So you would canvass all your points. You say all you have to say. Of debate. But when it comes to dialogue, you seek to understand. So debate and dialogue, even though they both start with the D, don't mean the same thing. Well, everyone's voice matters. Everyone's voice matters. That means, irrespective of the person's status, their voice matters. Now, dialogue is respectful. Disagreements, there might be disagreements, but there is no hostility. In dialogue, there's curiosity. When you said this, what do you mean? So you are asking questions to know, not to judge. Dialogue is collaborative. it aims to build shared understanding, not to judge, not to condemn another person. Now let's look at the difference between dialogue and debate. In debate, you aim to win an argument. Don't forget, dialogue is to what? To restore peace, to resolve the disputes. While dialogue is to find understanding. Debate is to win an argument. Dialogue is to what? Find understanding. Debate is focused on defending your view. You just want to show that what I'm saying is right. We should not do it this way. This is way it ought to be done. That's a debate. But when it comes to dialogue, we focus on listening. Why? Because you want to what? Find understanding. In debate, you can interrupt, just as in court. There's objection, my lord. This question that the claimant counsel is asking my client to think that question is misleading or is in like bringing another crime, is out of point. So you can interrupt when it comes to debate. But when it comes to dialogue, we encourage reflection. You allow the person talk. You allow the person express themselves. Now, dialogue is cooperative, while debate is competitive. It is my own opinion must win. But in dialogue, we put all our opinions to the table and we look at it. Which one will understand the ideas and would what implement the one that will feel will suit the goal. Now, difference between active listening, or essentially, let's look at what is active listening. Active listening means to fully focus on the speaker message, both words and emotions. Now, when we started, we gave an example of the two brothers story. I believe we can still remember the two brothers story. Now, we said the elder brother felt not respected, and that was the essence of the dispute. So, in dialogue or in dispute resolution, when it comes to mediation, it is essential that we listen to both the words and the emotion. So even in our personal life, when we are in a misunderstanding with someone, it's essential to listen to the emotion so that we would what? We understand the words that are spoken and the emotions that are displayed. Now, what are the techniques of active listening? Techniques of active listening. Number one is to pay attention. Is to pay active attention. To give our full focus. So as a mediator in resolving disputes, you don't have to be taking your phone. You don't have to be, let me just check my WhatsApp. No. Let me check my, what's going on? There's a notification coming from my smartwatch. That's a distraction that can make the person want to fully open up. That would maybe help the person to reduce the level of openness when it comes to that dialogue. So it's essential that we pay attention. Number two, we reflect and rephrase. So when you're saying, and when the money that was owed, it was not paid. So what would I say as a mediator? I would say, so you are saying that the money was not paid. So you would reflect and rephrase so as to be clear on what the person is saying. Now, also, we have to validate feeling. Say, oh, I felt hurt by what the person did. So, what I would just say is, oh, I understand. I can see why this upsets you. I can see why this might hurt you in a way. And number four, we ask clarifying questions, such as, can you help me understand what you meant by jagun jagun or any word? What do you mean by this? So we'll ask questions so that we'll be clear. Then at the end of the story, it's essential to summarize so that the person will know. Would you like, as the mediator, you understand the dispute, you'll be able to rephrase to the person to understand that, okay, this is exactly what I said and I was actually heard. So listening is the first act of peace. To achieve peace, listening is very essential. A peace ambassador resolving disputes, I must learn the act of what? Listening. Now, intercultural communication in peace building. Peace ambassadors in Nigeria and Africa, we operate in a multi-ethnic and multilingual, multi-religious, multicultural societies. For instance, in Nigeria, we believe we have over 250 ethnic groups. So having 250 ethnic groups, even in the, let me say, in Kogi State alone, I believe maybe they have more than 20 to 50 ethnic groups just there. How much more coming to other states, among others. So in resolving disputes, even among people of the same tribe, they might have different opinion, different beliefs in their ethnicity. So it is essential that I understand each ethnic group opinion or idea. Now, I might not know everything, but I must be open to learn and be culturally curious. Now, what are the key guidelines? Number one, be culturally curious. Learn basic greetings and customs of different groups. I remember our trainer then said they went to resolve disputes to in the northern states and they were Muslims. So what did he have to do? He just uh, employ like went to meet one imam and the imam explained, oh, this is how this tribe does, this is how this tribe does, and he brought him during the mediation session. I mean, during the training session, he was training some people there, and he brought him and he explained to me, and he was the one that helped them in an aspect to explain some things that helps the people to better understand because of their culture. So as a peace ambassador, I must be culturally curious. You know, I can just ask, what does this mean in your culture? Oh, how does this apply in your culture? Another one is I must avoid stereotypes. Treat people as individuals, not as representatives. Also, respect silence. So silence does not always mean acceptance or agreement. Sometimes silence is just a means of reflection or person is just thinking sometimes. Now, recognize cultural power dynamics, age, gender, hierarchy, influence, and communication. You must understand the cultural power dynamics. So, for instance, in the northern Nigeria, it is good like to allow the elderly one to speak first. I believe in Southwest too, it's like that. If two people are fighting, it's good that you allow the elder to speak, then maybe the younger will speak. But we'll get to the procedure in the next module 6. All right, so psychology of communication. Psychology of communication. We are to listen to understand, not to respond. Must listen to understand, must acknowledge emotions without judgment, must keep our voice steady even when others are emotional. Just as Mr. Promise shared with us that when, as a peace ambassador, I've brought in my emotion, there is likelihood I'm going to escalate the dispute when I begin to apportion blames. But I must keep my voice steady and I must not get emotional or kick in from the emotional angle. So use pauses, silence often encourage reflection. So there's an example we gave here that when people are in disputes, you allow them just to take pauses. Sometimes they would reflect and see, oh, this is not really even what the dispute. Dialogue and reflection help people to resolve the dispute just on their own. Because one thing I know, and we have seen in the course of this training, dispute is personal. And we said, as an individual, I must have inner peace so that I can always give it. Because you can't give what you don't have. Now, the role of storytelling, I mentioned this earlier, that storytelling is a powerful peace building tool because stories humanize conflict. Let the people say their story. So when people tell their stories, they express their pain, values, and hopes. So listening to these stories builds empathy and dismantle prejudice. So as a peace ambassador, I must invite disputants to tell their story. There's this law term, the audio term per term, that you must hear both sides. So as a dispute peace ambassador, I must allow the disputants to express themselves. Let them say their story. Let them say their side. So hearing one side and giving opinion is injustice on the part of the other person that was not heard. Now we must use reflective questions to draw lesson. So after the dispute has been resolved, you can just ask the parties, what do we learn from this experience? How can we prevent future ones, or how can we look at resolving the ones that might something like this that might occur in the future? So also we must share success stories from other communities to inspire hope. So in resolving disputes, we must share success story, we must let the other party like encourage them to resolve the disputes amicably, just by saying, oh, there was one dispute last week. Miss Peace is not here. I invited her over during the course of last week to join me in a mediation session with for some parties, but we're still on it. So it won't be for this training, maybe for subsequent ones. All right. So there are three levels of listening when it comes to dispute resolution. The three levels of listening. We have the internal listening, hearing through your own bias. Just, just, just look at it. Okay, I know what you want to say. That's in your mind. Number two, focus listening, paying attention to the other person's words and emotion. This is also good, but it's not the best. We also have the global listening, noticing tone, body language, and atmosphere, and reading the whole room. So global listening covers every aspect of listening. So as a peace ambassador, I must cultivate global listening. So in global listening, we understand what is said, what is felt, and what implied. What is said, what is felt, and what is implied will be understood. So let's proceed. Already 30 minutes to module 6. Module 6. Mediation practice and case management. So I want us to pay rapt attention because this is the practical aspect of mediation and dispute resolution. Now, when you talk about mediation, mediation is not just something that is done by the side. Mediation is an art and a science. It requires emotional intelligence, communication skill, and procedural structure. We've seen emotional intelligence in the last class. I just concluded communication skill just now, and we are looking at what the procedural structure now. Now, to do rope mediation and conciliation locus, of course, our registered name is Do Rope Foundation for Peace, for Mediation and Social Harmony. Do Rope Foundation for Mediation and Social Harmony, but we use Do Rope Mediation and Conciliation locus. Now, mediators are trained not only to help people settle disputes, but also to restore trust and relationship. So it's not just to resolve the disputes. That relationship must be restored. And initially, I mentioned that where there is no relationship, we don't force relationship to exist where it doesn't exist. But where it exists, we do well to restore the trust and relationship. Now, mediation practice is guided by three fundamental principles. There are three fundamental principles that guide mediation practice. We have the neutrality, how that a mediator must not take sides. I don't have an opinion on the disputes. I don't take sides. I don't feel who is right or who is wrong. I am focused on resolving and restoring relationship. Because the moment you take side, you will not know, you will not be able to do that effectively. Number two, voluntariness. Oh, this is something that is sweet and it's something that ties everybody. The parties have to do that voluntarily. Participation and agreements are freely chosen. Can't impose it on them. It is voluntary. And number three is confidential. The confidentiality. So discussion remains private. That is why they do not go to court, because when we look at the difference between ADR and litigation, we said cases before the court are reported in the law report. But when it comes to ADR, they are confidential. ADR keeps the secrets, so they are confidential. Fairness. In mediation, fairness is the process, peace is the outcome. In mediation, fairness, being fair, is the process. Peace is the outcome. Please, can we hear me? Please, can we hear me?
Yeah, I can hear you.
All right. And one more person before I proceed. Mr. Christian, can you hear me?
Yes, I can hear you.
Hear me?
Yes, I can hear you. I can hear you.
All right, so let's proceed. Thank you. Now, let's look at mediation framework. Mediation framework. The Alternative Dispute Resolution ADR framework provide a standard approach to managing disputes outside the courtroom. Now, we have laws that provide for this. We have the Arbitration and Conciliation Act 2004, now amended to Mediation and Conciliation Act 2023, which we call the new act. This one it's correct some lacunas that we had in the 2004 Act. We also have the Lagos State Citizen Mediation Center Law 1999, and we also have different High Court civil procedural rules of different courts. I remember that of those states provide that matters was given to alternative dispute resolution first to resolve the dispute out of court, try to resolve it through negotiation and other alternatives so as to arrive at terms of settlement before even filing the case in the first place. Now, this frameworks emphasizes that mediation is voluntary, confidential, and party-driven. The frameworks provide that mediation is voluntary, parties choose to, confidential, and party-driven. So, conflicts, what are the process, the procedure to mediation? We have the conflict has happened, then there's a request for mediation, then the mediation process, an agreement, and what follow up. There's a conflict, there's a request for mediation, there's a mediation process, there's an agreement, and there's follow up. So we'll look at it now. Now, what is the stage one? Intake and premeditation mediation preparation. Now, let me just give us a scenario. When I was working as a volunteer at the Citizen Mediation Center under the Alimosho local government in Ikoton, at the Ikoton office. The first interaction we have with the disputant is at the complaint desk. So you come to the complaint desk, which is the intake and pre-mediation preparation. So it's the complaint desk. You come and lay your complaint. So that is what we have here. That is intake and pre-mediation preparation. So what happens here? We receive and register the dispute. Okay, I am Mr. Tajuddin. My tenant, Orelope, whatever, has not paid my rent for 6 months. His rent expired in April and he has not paid May, June, July, August, September, October, November. Oh, it's even 7 months already. Okay, 6 months as at the end of last month. So let's say 6 months and he's owing me. I want him to pay my money and move out of my house. That is the complaint. So Mr. Tajuddin is the one that brought the complaint to the desk. That is what the intake and what premediation preparation. So at that point, we ensure that we receive and register the dispute. We ensure parties understand mediation is voluntary. And okay, we'll just tell them, okay, tell us your story, we'll write it out. There's a complaint sheet, we'll write it out. Then we tell you that okay, we're going to invite the other party. We'll see how the Korea people will invite him through the Ministry of Justice. We'll gather information that are necessary. Then we'll give them a date. That's the intake and premediation preparation. Number two is the opening session when we have given them dates and they are now here to resolve this. So usually the first thing we do, the mediator will introduce, oh, hi, I'm Uluwashun Uluwatosin. I am going to be the mediator for this session. I then they will introduce themselves. That's the opening session. So he explains to them that mediation is voluntary. And something essential to be done in this opening session, they have to fill the consent form. They will feel it that they are giving their consent because it is what? Voluntary. So knowing that it's voluntary, that means we need their consent to what? To proceed. So after they filled their consent form, as the mediator, I will explain to them, this is a voluntary procedure, it saves you time and it helps to restore relationship. This is dispute resolution. It helps you to build a good rapport and help you to build trust. So mediator will explain the procedure and all that it entails to them. Now, what are the ground rules? When it's time for the parties to speak, we looked earlier, we just now concluded that everybody must have the floor. They must say their story. So one person talks at a time, no interruption, confidentiality applies to all. So I will allow each party to say their story. Number 3, opening stage. Each party narrates their version. Okay, this is still part of the um opening stage. Opening stage will happen to both the meet and greet and also the disputes. We open the disputes now. Then each party will explain, narrate their version of the conflict without interruption. Mediator listens, takes notes, and observes body language. Now, mediator techniques. So we use active listening to understand, summarize each party's view, and we identify emotional undertone and unspoken concerns. Number 4, the fourth stage, the mediator and to identify the issues. So the tenants used to what example can I give as the underlying need of Baba, what's his name? That Baba, there's a T word I use, T name I use, but let's proceed. So I say, okay, this tenant is not greeting me every time he sees me through his window. So what's the underlying need there? The landlord wants the tenant to be greeting him well. Now, that's not the issue that he brought during the booking. He just said he wants the tenant to leave the house. That was what he said. Now, does he want the tenant to leave the house? Sometimes, yes. Does he want his money? Of course, yes. But there are other underlying needs, underlying issues that would notice when each person is saying their story. So once both sides have spoken, the mediator helps them to identify the real issues. Often, what people argue about is not their actual cause. What they argue about is not that there's something else that is not being said. All right, so let's proceed. So write issues visibly on a board paper or on a sheet of paper. So in this instance, we'll write number 1, we are discussing tenancy, end of tenancy. Number 2, communication breakdown. Number 3, lack of respect, or let's say the tenant too. Number 4, lack of privacy. Let's say the landlord is not even giving tenants any privacy. I'm leaving your house, you're not giving me privacy. Why should I pay? So we'll now analyze or itemize, identify the issues. Then there will now be a joint discussion. We'll now, okay. So this first issue 1, just like answering law questions, we have the hierarchy rule, identify issues, the rules, the application of the rules to the issue, and the conclusion. So you now apply, okay, let's resolve each dispute. When do you want to pay the rent? Okay, I'm expecting one money next month, I'll pay. Okay, Baba, can you hold on till next month? I cannot hold on, no, I want to pay my daughter's school fees. Okay, is there a way you can work around it? When the tension has gone down, people will think now and there would be a way out. I'm just giving a rough idea of how to go about it. Okay, number 2, issue of breakdown in communication. Tenants, is there an issue that makes you not to greet the landlord? Ah, I'm busy now. I can't be coming out to come and be greeting you. If that said, the landlord, why are you not giving the tenants? Why are you not giving the tenants free freedom of privacy? Why are you not allowing the tenants to be um enjoying their privacy in their own house? The house used to be my house, so I'm just used to that environment. So what will you do? You will give them a level of privacy so that they can enjoy the apartment. So that said, we must identify the issues and resolve them. Identify the issues and resolve them. Also, that's where the joint discussion and negotiation encourage parties to express their needs and not demands. Some people have unrealistic demands, so we would help them to identify the needs. We'll ask open-ended question: what would make this situation better for you? Okay, just ask the tenants. What do you think will make the situation better for us? Ah, the man should not be passing in front of my house. There's a way he can pass. I don't know why we always pass here. So that will make it. I will ask the other party, can you work with this? It's voluntary. Both parties will look at it together and will arrive at a what? A conclusion. Now I mentioned caucusing. I've been mentioning caucusing. Caucusing is a process that we take each party aside to discuss. Now, if emotions run high, the mediator may meet privately with each party. Let's assume that in a dispute, as we are talking, the other party just started crying. you know, that one emotion is already high, and all we do just take that party aside. This is actually optional, it's not a must. Sometimes we don't need to, but sometimes when emotions are high, you allow emotional expression in a safer space or where there is an imbalance of power. Let's say boss and staff say, ah, if I say what I feel in front of my boss, they will fire me. Oh, some things like that. So caucusing will allow the other party to feel safe and express themselves sometimes. Now, caucusing also helps to clarify interests and priorities, also explore confidential settlement options. So sometimes in dispute resolution, in my experience, we'll see that the person when they are talking, say, I will not agree. That's not why I don't want that. I will not never will I accept that. Okay. So we'll go and do caucus now. Look at it together. Okay, you don't want to give. Let's go back to this example. He said he's expecting money next month, that is doing contribution, and he will pack next month. Let him stay till next month. It's just about how many days to next month? 14 days. Is it even up to 14? Today is 17. 13 days. 30 days are September, April, June, and November. So November has 30 days. So let him stay 13 more days. By the end of this month, he will pay you. So reasoning with Baba, he will say, okay, Isha will write the agreement. Ah, that one is the smallest. He will write now. Then by the Baba that was hell bent that wanted his money today, we agree to wait till month end just by what caucusing, clarifying interest and priorities. Also, it also helps to explore confidentiality and settlement options. However, never pressure a party in caucusing. So it is not our road to, oh yeah, tell me. You know, it's still voluntary and confidentiality must be maintained, which is absolute. Number seven, the seventh stage, agreement and closure. After back and forth, everybody, there is now an agreement to sign. So clearly write out the settlement terms. We call it terms of settlement or settlement agreement, and we ensure both parties read and sign them voluntarily. They will thank them for their cooperation and commitment to peace, because that will be part of what will be the opening statement, that this is to promote peace, cordiality, and harmony. So thank them for cooperating. So this is a sample of the format for settlement agreements. So agreement should be practical and fair and enforceable. Now, there's a principle when it comes to justice or what grants jurisdiction to a court is that the objects of the disputes, like the judgment that will be given, must be enforceable. So when they want to come and resolve a dispute that the outcome is not enforceable, that is unnecessary. So the agreement should be practical, must be fair, and must be what? Enforceable. Just as the example we give, okay, I'll pay the money by month end or first of December. That's practicable. Okay, I will do this. I will not pass the front of that house again since there is another way I can pass. You can't say there is no another way. Should the man be flying? He can't fly. So the agreement must be practicable. Now, mediation ethics and standards. We said neutrality, mediation must be what? Impartial and avoid biases. Confidentiality. A mediator in the process of discussion, they must ensure that they are private and both parties agree. The next one, voluntariness. Participation and agreement are freely made. Must ensure that the agreement, participation, everything are freely made. If not, it would make the process void. Now, consent. I mentioned that they must sign the consent from voluntariness. How that at the opening stage they sign the consent that are giving their consent to the process. Now, competence. The mediator are trained and they are to act to the level of like as up to the training skill. Like mediators must be trained and act within their skill level. So we must act all the training that we are receiving, we must act on it, we must use them when resolving disputes because that is what will make the agreement to be valid. Now, respect and dignity. Every participant is to be treated with respect and dignity of human person, which is fundamental human right under the Nigerian Constitution. So every participant, every disputant must be treated with utmost respect. Now, documentation and case management. Proper documentation are to ensure accountability and continuity. Now, okay, we'll get there. There is a follow-up part when it comes to dispute resolution or mediation. That follow-up part, everything that happened before, during the resolution, the agreement, and the follow-up, anything that comes up must be what? Documented. Proper documentation ensure accountability and continuity. Now, essential mediation documents, so the intake form, the attendance sheets, mediator notes, settlement agreement, and follow-up form. So these 5 documents are essential when it comes to mediation. These are the documents that are very, very essential. The intake form, that's a complaint form, like call it in the citizen mediation center. We have the attendance sheets, sometimes we call it the consent form. We have the mediator's notes, we have the settlement agreement, and we have the follow-up form. Follow-up form is just a simple dispute, like just this example I gave. On the 1st of December, the tenant paid the landlord. Write it there, the follow-up form. So all those documents will be in the file of Mr. Bakari versus Mrs. Ogunde. So it will be in the agreement, in the file of the parties. So this is an example. For most of the cases that we handle in BESA, we have their case number as 001 GBS ABJ 321, something like that. So that's how we name or we give them case number. All right. Common challenges in mediation. We have power imbalance, and I mentioned that that we can use carcosing to ensure that the other party opens up. Another challenge is bad faith when a party refuses to cooperate. That's a very, very, very challenging issue. You know, when a party just say he's not cooperating, it's voluntary, so you can't impose. So the only thing a mediator will do now is to reaffirm ground rules and we focus on their interests. Say, what do you really want? You want this man to pay your money. So you will get it. It doesn't have to be through the hard way. So we'll just ensure that we reaffirm ground rules and we focus on the interests. Emotional outburst, anger disrupt the process. When one person is venting, Allow them to vent, but tell them, use a calm tone. Don't raise your voice. Say what you want to say without shouting. Allow the parties to voice. Let them say their mind. Let them express themselves. So cultural barriers, misinterpretation of gesture or terms. So what do? We show cultural respect and clarify meanings. Unrealistic expectation. Now we said in mediation, we focus on their words, their the needs, the interest, not unrealistic demand. Some people can have unrealistic demand. I want him to be paying me 10,000 interest. How? Tenants is only 100K. You should not pay 10,000 interest for the 6 months. That's unrealistic. So what do you do as a mediator? I will educate the on mediation limits because it's a win-win. You don't win all, you win some, and you allow the person or the other party to win some as well. So monitoring and follow-up. Mediation success depends on follow-up. Now, what do we do at Duro Peace Ambassador as Duro Peace stage when there is a promise? We follow up to ensure that that promise is kept. Just as the example, the landlord and the tenant I gave now. That tenant that promised to pay by 1st of December, we were sure that he pays. I remember, is it last month? Last month, thereabouts, I was involved in a dispute. Morning and night, sir, please. I don't want us to take this matter beyond what it is. You've already agreed. I kept calling. He even got to a point, the tenant was now calling me that his vehicle got spoiled. Is this one story? I just kept following up until that agreement was complied with. So follow up is very essential. So sometimes we offer additional dialogue session if new issue arises. So just like that example I'm giving now, the tenant kept saying, his vehicle got spoiled. And the Baba was calling me, the landlord was calling me that he has not packed though. Tomorrow is the day. I said, I'm in communication with him. And as per the agreement, he said he will pack. So let's give him till the end of tomorrow. So by the end of the tomorrow, he called me again. He has not packed, but I saw him packing some things. Hey, you saw him packing some things. Now let's give him till tomorrow, since today is the day. And by the end of the other day, the man had packed. So we document all post-settlement actions. So we document all the things that happened before, during, and after the settlement. All right, so that will be the end of today's class. Do we have any question? Any question? Any question? All right, so in the absence of question, let me just summarize the takeouts from this last session. So mediation is structured, yet it's flexible. It prioritizes relationship over rulings. Now, ethical standards, fairness, and trust must be maintained. As a mediator, as a peace ambassador, I must keep record to ensure what? Transparency. Good record to ensure transparency. So, Europe mediators, we are what? Peace builders, and we are professionals. Yeah, we do it the right way. Now, every documented success added bricks to the foundation of the peaceful society. So, as a prospective peace ambassador, we're on a journey to make our world peaceful, to have people that, irrespective of the conflicts that might arise in the relationship, they're able to navigate the conflict and build trust and make such relationships stronger and better. So that's the essence. And I believe that even in our personal life, we'll do well to live in peace with people. We'll do well to have a peaceful mindset towards people so that we'll together live in a peaceful world and we'll be able to promote peace as we ought to. So good evening, everyone. Thank you for today. I'll share the soft copies on the group, as well as the video will be available on our YouTube. You can go and watch it. Good evening. Thank you so much.